Hello and welcome to this program from the Center for the Restoration of Christian Culture at Thomas More College. We have a really interesting subject today and a really interesting guest. Michael Gilleran, who's the Vice Chairman of the Board of Thomas More College, is an attorney who has been involved in a fascinating court case coming before the Supreme Court this year, this term, with very important implications for religious schools, independent schools, and home schools. Michael Gilleran, why don't you tell us about this case and why it's so important?
The case is called Espinoza versus Montana Department of Revenue. And the case centers around two things. One is Kendra Espinoza, who I've met, and her two daughters. And Kendra is a single mother living in Montana who is a very, very intelligent lady, but she works as an office aide and sometimes as a janitor. And she lacks the money as a single mother to pay for the schooling she wants for her two children who've had a difficult time in public schools. And she has sent them to two private schools, a non-denominational Christian school in the Kalispell, Montana area, which is western Montana. She did this with the help of a program in the state of Montana enacted by the legislature, which provided for tax credits. Taxpayers can get a tax credit on their state tax returns. They can check it off. Those funds, $150 per taxpayer, seems like small dollars, can then go into what is called a scholarship fund. The scholarship fund is then run by trustees of the scholarship fund. The scholarship fund is then enabled to divvy out that money to qualified schools. Qualified schools. And qualified schools must provide a full program of secular education. The entire state secular educational program must be there. But under this state program in Montana, they could also be religious schools. So the program, the tax credit program, is, let's call it neutral. And it provides for the use of what essentially is public funds, but not directly from the public treasury, public funds by private choice to go to a religious school, including non-religious schools, also secular schools, and solely by the choice of the parents and children who go to those schools. And the money must be used substantially for a secular purpose, which is the secular educational program of those schools. Okay. So Kendra Espinoza arranged for her two daughters to get these scholarships to go to this non-denominational Christian school. Now then what happened is this Montana Department of Revenue, based upon a state statute in Montana, which the state of Montana calls the Anti-Aid Amendment. Anti-Aid Amendment blocked this program and prevented it from functioning, and the disbursement of funds to the scholarship fund prevented that based upon this state statute. These state statutes are generally referred to because they derive from a time period in the 1870s and 1880s, believe it or not. These are called Blaine amendments. Now, let me take a little digression. Who's Blaine? James G. Blaine was a congressman from the state of Maine. And Blaine was a rabid anti-Catholic person. Rabid, I'm not kidding when I say that, rabid. And he helped to promulgate in the U.S. Congress something called the Blaine Amendment. This is in the 1870s, 1876 in particular. Now, at that time, digress some more. At that time, into the U.S., after the Irish potato famine, and it's mostly Irish, huge numbers of Catholics immigrated to the United States in the 1840s. I'm from Massachusetts, and let me just tell you some of the numbers. By the early 1850s, 25% of all residents of the city of Boston, 25% were now of Irish descent. And almost all of these would have been Catholics, almost all of them. And so in the Commonwealth of Massachusetts, society was changing very, very rapidly from a largely Protestant society into a society with a substantial Catholic minority. And Blaine was the product of that changing world. And in Massachusetts, there was a tremendous movement, even before Blaine, to block the Irish from having jobs, and especially from having any use of public funds to support Catholic schools in any way. I can go into this in more detail in a moment. So even in 1855, 1854, Massachusetts was already passing its own anti-aid amendments, which are now called by people like me the proto-Blaine, the before Blaine amendments. So Blaine in 1876 is the product of these rabid anti-Catholic influences. Let me just read to you briefly part of the platform of the American Party from their convention in 1855, paragraph 8. The American Party is against the Catholics, and it says here, they are for resistance to the aggressive policies and corrupting tendencies of the Roman Catholic Church. And you can find endless numbers of other things like this to support the clearly anti-Catholic origins of the Blaine Amendment. The speeches given in the U.S. Congress are full of anti-Catholic references, constant anti-Catholic references. Now, the Blaine Amendment did not pass. It had to get 3/4 of both the House and the Senate, and it failed in the Senate by 4 votes to get the required vote. But then what happened is people like Blaine and others began to promote these Blaine amendments in the states. And the states obviously didn't have the problem with amending their constitutions that the United States does through the U.S. Congress. Montana in the 1880s was a territory, and it was growing rapidly in that time period. And by the late 1980s, it was in a position to become a state. The U.S. Congress passed an enabling act in 1889 to make Montana into a state. And in that enabling act, it said, Montana can become a state if it enacts an anti-Blaine amendment. The only way Montana could become a state is if it enacted legislation, not just legislation, put in its constitution, a Blaine amendment, and I'll read you what the language is in a minute here. And so that's how Montana was conceived, through the requirement of a Blaine amendment. The Blaine amendment in the state of Montana says, and I'm reading it now, in its Article 10, Section 6 of the Montana State Constitution. It's not that long. The legislature, counties, cities, towns, school districts, and public corporations shall not make any direct or indirect appropriation for payment from any public funds or monies or any grant of lands or other property for any sectarian purpose or to aid any church, school, academy, seminary, college, university, or other literary or scientific institution controlled in whole or in part by any church, sect, or denomination. So the main points of the anti-aid amendment is money for a sectarian purpose controlled in part by a church. Now, let me digress one more time. In Massachusetts and many other places at that time period, the public schools were what were known as common schools. Common schools. And common schools were funded by public funds. And common schools taught, as part of their curriculum, a general form of Protestantism. Now, when I say that, I'm not kidding. And what that meant was all devotional practice, and those schools had devotional practices, were of the Protestant nature, and anything of a Catholic nature was prohibited, and students who engaged in any kind of Catholic devotions were subject to corporal punishment. I am not kidding you when I tell you this, and I know this very well from the Massachusetts experience. So common schools in those days were essentially Protestant schools, and these were funded by public funds. By the way, you should know that in those days also, out of the public treasury of the state of Massachusetts, where I live, public funds were used to support Harvard College and Amherst College. You may not know that. But public funds were used all the time for what might otherwise be seen today as private purposes. But in those days, were viewed as, well, this is what we as Protestants do, is we fund our Protestant institutions. So, one more point about Montana, and I know Montana well because two of my great uncles lived there in those days, in the 1880s. These might be great uncles. And Montana at that time had a party called the American Protective Party. Sounds like the American Protestant Party. And they enacted a statute in Montana that no teacher shall be hired into these common schools who is subject to an un-American ecclesiastical power. Un-American ecclesiastical power means Catholics. No Catholics were to be hired with the use of public money. And so, in other words, there was a strict religious test, of course, which is prohibited under the U.S. Constitution. A strict religious test that no Catholic could get a job working in the public schools and with public funds. That was the truth in the case in Montana in those days. Of course, these things are disgusting, reprehensible. By the way, let me just tell you that in the oral argument, which took place in January in this case, Justice Kavanaugh, as part of the oral argument, made a statement publicly about this very point, which may not, yes, here it is. In referring to the Blaine amendments, he said publicly, this is on the public record of the case, on the transcript, you can read it yourself. The Blaine amendments, they're certainly rooted in grotesque religious bigotry against Catholics. And this history of these Blaine amendments, by the way, is also taken up by others U.S. Supreme Court justices, including Justice Thomas. By the way, many of you may not know that Justice Thomas was raised by his Catholic grandfather in South Carolina. And he wrote a decision in a case called Mitchell v. Helms in 2000, and he said, this is Justice Thomas now. By the way, I don't think Justice Thomas is Irish, just so you know. Okay. He said, in his plurality opinion about the Blaine amendments, he said, hostility to aid to pervasively sectarian schools, that's Catholic schools, has a shameful pedigree that we do not hesitate to disavow. Now he's writing for the court. Although the dissent in that case professes concern for the implied exclusion of the less favored, again, they're talking about Catholic schools, the exclusion of pervasively sectarian schools from government aid programs is just that, particularly given the history of such exclusions. Opposition to aid to, quote, sectarian schools acquired prominence in the 1870s with Congress's consideration and near passage of the Blaine Amendment, which would have amended the Constitution to bar any aid to sectarian institutions. Consideration of the amendment arose at a time of pervasive hostility to the Catholic Church and to Catholics in general, and it was an open secret that sectarian, the word sectarian, was code for Catholic. In short, nothing in the Establishment Clause requires the exclusion of pervasively sectarian schools from otherwise permissible aid programs, and other doctrines of this court bar it. This doctrine, born of bigotry, should be buried now. I'll get into the arguments in just a minute. So those are the Blaine amendments. So in Montana, the Blaine amendment was used in the case of Espinoza to block the operation of this state statute provided for the tax credits. The state Supreme Court in Montana upheld the action of the Department of Revenue of the state of Montana and struck down the scholarship money used by Kendra Espinoza to help her two daughters go to a private religious school. Struck it down. The state, however, knowing that the case would be taken up to the U.S. Supreme Court, or thinking it would be, granted a reprieve while the case is now pending before the U.S. Supreme Court. Now, I'll get into the arguments in just a moment, but so Kendra Espinoza lost in Montana Supreme Court. She then applied to the U.S. Supreme Court for something called certiorari, which is a Latin term meaning a writ, or a writ to be issued by the U.S. Supreme Court to the state court in Montana that says, let us make certain. A fancy way of saying Kendra's asking the U.S. Supreme Court to take up this case on a discretionary appeal to make certain what the law is in her case. And the U.S. Supreme Court late June of 2019 granted certiorari. By the way, the number of cases in which certiorari is granted is infinitesimally small. Granted certiorari to Kendra Espinoza in this case, and heard argument in the case on January 22nd before the U.S. Supreme Court in Washington. And then I can tell you about what happened there and the arguments made there and so on.
Let me just incidentally confirm what you said about religious intolerance. My great-grandfather was caned for missing school in Boston public schools on Christmas Day. But the question I wanted to ask you is, your legal practice is ordinarily in financial affairs. How did you become personally involved in this case?
Here's how all that happened. I've been practicing in financial affairs all my career as a lawyer, but as a young lawyer, I was a volunteer aide for someone by the name of Raymond Flynn, the mayor of Boston. And I was an active aide for him for many years, volunteer. That was my night job, working for Ray Flynn. My day job was working for the largest law firm in the city, which did not have many Catholics at it in those days. And as a result of that, some years later, I was asked to get involved in a petition to help overturn the Massachusetts Blaine Amendment. The anti-aid amendment in Massachusetts, the oldest one, by the way. In Massachusetts, we're always first in our anti-Catholicism. We take pride in that, or at least for many years the state has, for sure. In spite of the fact that a huge Irish population did come to Massachusetts with its Catholicism. In any event, so I was involved in the case to help get a vote to overturn the state constitution in Massachusetts, and there was a case about this concerning the signature papers we had to get it on the ballot. And the case itself was fascinating. What happened in that case, the issue was many of thousands of our signatures were disqualified by the then Secretary of State because if someone would come up to use the signature paper and sign and then put a squiggle or even a coffee stain on the paper, the Secretary of State of the Commonwealth of Massachusetts disqualified the entire paper. And the teachers' unions argued that any squiggle might be a secret religious symbol and could therefore be a cue to other practitioners of religious faith, especially Catholics, that they should automatically sign this paper. And the state Supreme Court took up that view and endorsed it, believe it or not. I was involved in that case. It's shocking. The case is shocking. A year later, in another case I was involved in that did not involve the Blaine amendments, but was a U.S. senatorial candidate running against Ted Kennedy. His papers were filled with squiggles and doodles. But the state Supreme Court said, oh, that's just a political case. Squiggles and doodles are just fine. And so that Massachusetts now has one rule for religious matters, squiggles and doodles are absolutely disqualifying the entire paper. And if it's a political matter, squiggles and doodles are of no effect whatsoever. Strange and bizarre, but that's how I got involved. And I met many people active in this area at the time. And so when this came up last year, people who were involved 20 years ago knew I was involved then, and that's how I came to be involved now.
Okay.
And a long history of religious activism, shall we say.
And tell us a little about the main thrust of arguments in this case.
The main arguments go like this. The First Amendment has two very important provisions in it. One is it guarantees Congress shall make no law infringing upon the free exercise of religion, nor shall Congress make a law which establishes a religion. And these two clauses are critical. In addition, the 14th Amendment says that all people shall be entitled to equal protection of the law. It was what we call the Equal Protection Clause. So these two provisions, these two amendments to the Constitution, the first and 14th, are of critical importance. In addition, the U.S. Supreme Court has for some time looked into whether something called animus or hatred may stand behind action by a governmental entity against anyone, and that this animus can be taken into account, including in the religious context. And the leading case there is a case called Masterpiece Cake Shop. You may recall this case, where a baker who was claimed to do masterpieces, artistic cakes, did not want to do a wedding cake for a same-sex couple. And the various governmental entities which were then, I believe, involved with his licensing made statements. He made statements in his connection to punish him, which were overtly hatred statements directed toward him for his religious belief against same-sex marriage. And these statements were rife among the board or governmental entity that was involved. And these statements were then used in Masterpiece Cake Shop to invoke the doctrine of religious animus was directed against this man, and the government sought to punish him. And the U.S. Supreme Court held in Masterpiece Cake Shop that animus could be a ground for concluding that this man's rights were violated, and the government was not acting in some kind of inherently neutral way, and that's how that gentleman won his case against the U.S. Supreme Court. So the animating principles were the First Amendment, the 14th Amendment, and religious animus. And these were the issues that went before the U.S. Supreme Court. The arguments get even more complicated, however. And they go like this, other arguments. The state of Montana, before its state Supreme Court, engaged in a clever maneuver. It obviously wanted to preserve its Blaine Amendment, and most of the Supreme Court justices were appointed by a governor who, obviously the governor had charge over the Department of Revenue, which enacted the provision to block the Blaine Amendment. He also had appointed many of the state Supreme Court justices, and those justices came up with something clever, which is this. Instead of just backing up the Blaine Amendment, which I read, which said that no funds shall go toward a sectarian purpose or toward a school in whole or in part controlled by a church, recognizing that there were already Supreme Court cases which might say that such a statute would be in violation of the First and 14th Amendments, did the following. To try to avoid this entire problem, the state Supreme Court of the state of Montana struck down the entire tax credit program. Now remember, I said the tax credit program provided that you could use the funds for any private school, including a secular one, or a private religious school. So instead of the State Supreme Court of Montana striking down the use of the money just for private religious schools, struck down the program for anyone. And therefore, the argument can be made that, okay, the tax credit program's all gone, and therefore there is no discrimination whatsoever. Clever. And the state of Montana then took this argument in its defense to the U.S. Supreme Court. And the argument goes like this, which is now there's no harm being done at all, right? Because we got rid of everything. Secular private schools and religious private schools, all gone. And therefore, Kendra Espinoza and her children are not being harmed. And therefore, this is all good. We're clean. The problem with this argument is that the reason why the State Supreme Court of Montana took any action at all was because of its Blaine Amendment. They took action based upon a statute which contains any use of public funds to go to any sectarian institution, even though the use is neutral, is available to anyone, neutral, for a secular, primarily for a secular purpose, which is, again, that all the schools had to qualify by espousing and performing under the all the secular requirements for schooling in Montana. And the choice to go to this school was a completely private choice of Kendra Espinoza and her children. So the choice to get rid of the program is not a very effective argument, but certainly the state of Montana has made it. Lawyers call this standing. Unless somebody's harmed, they can't bring their case before a court because they're not harmed. Courts aren't here to simply pronounce their authoritative opinions on something where there's no real dispute among the parties. So Montana argued Kendra Espinoza and her children lack standing. They're not harmed. And that's an argument Montana made. There are a couple other arguments. Let me just have a sip of water here. That Montana also was made, which are kind of complicated. But let me go to I'd like to turn for a moment to the argument itself so I can then illustrate how some of these arguments played out. So I was there on January 22nd before the U.S. Supreme Court in Washington, and boy, it's a majestic place. I think it's like 4, maybe 5 stories high. The courtroom is just immense, enormous, with a coffered ceiling way up above. And behind the justices is a big curtain. It looks like they're coming down from Mount Olympus or from Delphi, where they go back behind this curtain and among themselves engage in deep thoughts. It's kind of like the Wizard of Oz, behind the curtain or somewhere. They know everything. They've got every thought figured out. They just come out and then pronounce what that truth is to us once they've already discovered it. In any event, it's a majestic place. And then to be there with the Supreme Court justices at their bench and the lawyers arguing. I was not one of the lawyers arguing. I wrote a brief for the Pioneer Institute in Boston. One of the people who helped write that brief was me. But the Pioneer Institute, we weren't one of the parties. We weren't counsel to Kendra Espinoza. That was something called the Institute for Justice in Washington, D.C., which had been involved in the case from day one. And they were the counsel for her, and they were at the counsel table, although I was right at the end of the counsel table and right up in front of the court. And then on the other side were the state of Montana and its counsel. So what happens is at the time of argument, every last seat is filled. To my left, just to my left, by a few people over, were reporters for the New York Times, NPR, major news services were there. It's really just an amazing setup to be there. And every last chair is filled. It's hushed. These bailiffs at the U.S. Supreme Court tell everybody to turn their phone off, and they tell you 4 or 5 times. They tell you, don't go anywhere, don't do anything, and think nice thoughts. They don't say that, but in other words, they're gonna control everything. And then the justices troop out behind their curtain where they've already got the truth, and things start. And it's really just astonishing to be there, because I've been in many courtrooms in my life, and often the distance between where you sit and where the judge is 10, 12, 15 feet, sometimes more. And here, the distance between my noggin and Justice Gorsuch couldn't be more than 6 or 7 feet. He's right there. Huh. The distance from between me and that camera was the distance between me and Justice Gorsuch. So they're right in front of you. And of course, all the others as well. Justice Gorsuch, on the right-hand side, Justice Kavanaugh, Justice Alioto, Kagan, Sotomayor, Roberts. Sotomayor was next to Gorsuch, and then Justice Breyer. And the Institute for Justice went first, its counsel went first, and argued the following, that the state Blaine Amendment in Montana, based upon the First and 14th Amendments, was a violation of the Free Exercise Clause, but not a violation of the Establishment of Religion Clause, because the Montana program was completely neutral, available to all. The scholarship funds were available to all, and was for a secular purpose, largely secular purpose. Not doesn't have to be entirely, but just largely. In that it, again, I mentioned it has to follow the secular educational program of the state of Montana. And the decision to go to these schools was entirely a private choice. And under the interpretations of the First Amendment Free Exercise Clause by the U.S. Supreme Court, under those circumstances, any bar such as the state Blaine Amendment violates the Free Exercise Clause. Again, I pointed out that the Blaine Amendment in Montana said that no public funds shall go for a sectarian, let me just get the exact language, sectarian purpose, or to aid any church or school controlled in part by a church or sect or denomination. So under the decisions of the U.S. Supreme Court, especially a case called Trinity Lutheran, the Blaine Amendment is unconstitutional, because money can go to a church, can go to a school controlled by a church, as long as that money is otherwise available to all, not just at churches, available to all, not just churches, and goes primarily for a secular purpose, which is secular education, and is based upon private choice. So that was the argument made by counsel for Espinoza, and that argument is a good argument. That argument in practice is almost certainly a winning argument. In addition, he argued that he argued briefly, not extensively. He made the argument that the anti-religious animus argument. Now, the brief I filed on behalf of the Pioneer Institute, our brief was entirely based upon the anti-Catholic animus behind these statutes. We're from Massachusetts. The history here in Massachusetts, as you know, from your own experience, your own family, is replete with this. The evidence was huge that the Blaine amendments were based upon overwhelming anti-Catholic animus, and so he briefly made that argument as well. He also dealt with the arguments made by Montana itself, which I'll turn to now. Almost immediately, Justice Ginsburg raised the issue. And while the arguments take place, the justices have a practice whereby they ask questions. They don't ask permission. Can I ask you a question? They just ask them. And so Justice Ginsburg asked the question to counsel for Institute for Justice. And often these aren't questions, they're just statements. They're pronouncements. And her pronouncement was, counsel for Espinoza, don't you lack standing? Why are you here? Isn't it true that the Supreme Court of Montana struck down the entire tax credit program? So therefore, your client isn't harmed anymore. There's no program at all. There's no discrimination left. Therefore, you should lose, right? And he then started to make the argument I've already made, which was, no, that action by the court was based upon the Blaine Amendment itself. You've got to look at what the Blaine Amendment says, not the actions of the court to get rid of the program entirely. If the Blaine Amendment, which is the ultimate source of the decision by the Montana Supreme Court, violates the First Amendment, then the entire action of the court and the Blaine Amendment should all be struck down. After Justice Ginsburg asked this question, Justices Sotomayor and Kagan leaped, shall we say, pounced on this argument. And this was an argument only briefly made by the state of Montana in its brief. Briefly made because it's so weak. And it seemed immediately to me that it was obvious to me precisely where Justices Ginsburg, Sotomayor, and Kagan were going, which was, we're going to vote to uphold what Montana has done based upon standing. We will not address the underlying religious bigotry issues or discrimination issues. We don't want to. We don't want to decide the case on that basis because they had a big whopping problem, and it's this. A couple years ago, at a case called Trinity Lutheran, a U.S. Supreme Court case, Missouri had a program whereby it would rubberize playgrounds free of cost from the state anywhere. Again, neutral. Anybody can take advantage of this. Generally secular purpose, and anybody can get this. A religious school applied to have its playground rubberized. The state of Missouri said, no, we won't do that. Missouri didn't have a Blaine Amendment, didn't have one. And the U.S. Supreme Court, so this issue wasn't decided in Trinity Lutheran. The U.S. Supreme Court said, okay, here's a benefit generally available, neutral, not a religious purpose, private choice, you get it if you want it. And the U.S. Supreme Court said that the Missouri's bar on this to the religious school was a violation of the Free Exercise Clause. Okay, so Trinity Lutheran is not too far, pretty close to our circumstance. And this, of course, is an argument relied on extensively in the brief of Kendra Espinoza and the Institute for Justice, and is a real problem for Montana and for those who are on the other side of this issue. So the counsel for Espinoza relied heavily on Trinity Lutheran. And, okay, so then counsel for the Espinoza finished, and counsel for the state of Montana got up and began to argue. And Justice Alioto then broke in on that gentleman, whose name is Unikowski. He's excellent, by the way, and said this to the counsel for the state of Montana. Now, remember, the counsel for the state of Montana is attempting to justify the Montana Blaine Amendment. Alioto said, basically, speaking to Unikowski, basically what you're saying is it's permissible to discriminate on the basis of religion. It's not permissible ever to discriminate on the basis of race. That's what you're saying. Now, he paused, and everyone in that courtroom, almost everyone, was just what he said was so obviously true. I can only use the phrase, I was mortified. I was shamed to hear that such an argument was being made before the U.S. Supreme Court, that it's not okay to discriminate on the basis of race. We all know that. But it is on the basis of religion. And Aliotta called this out, that that's what Montana's argument basically was. And again, it was shocking, mortifying, that such an argument could be made to this day. And so that's Montana's argument. We can't discriminate on the basis of your race, but we sure can on the basis of your religion. And that's when Justice Kavanaugh also said, as I pointed out earlier, that these Blaine amendments, including Montana's, were based upon grotesque religious bigotry against Catholics. Now, obviously, people like me love the arguments, and they're great, and they're important. But we also have to count votes. So obviously, I'm sitting there listening to this, and I'm scratching down what's being said on a piece of scratch paper. Every last word I can get down that piece of paper, because I want to count those votes. I've got to get 5 votes. No matter how smart the arguments are, how good they are, or how much they're based in precedent, you don't get the 5 votes, you only get 4 votes, you lose. Now you already know you probably have got 4 votes. How do you know that? Because the U.S. Supreme Court has a rule that says when certiorari is granted, which was in this case, that is a decision to take the case up from Montana. In order to get certiorari, you've got to get 4 votes. You've got to get 4 votes. And so we know those 4 votes were there. Those 4 votes took this case up, and we've got to get the 5th vote. So I'm listening to people, the justices talking, and I know immediately that Ginsburg is against us, Kagan is against us, and Sotomayor is against us. Justice Breyer was a little unclear. Breyer voted with majority opinion in Trinity Lutheran. Wow. So Breyer is potentially gettable. Gorsuch also made a statement which made me think, we got that vote. Got that vote. Okay. And Thomas has written majority opinions in the past. I read one earlier, Mitchell v. Helms, which took close account of the long history of the Blaine amendments and excoriated them. So we knew we had probably 4 votes there. And Roberts made soundings that I thought were strongly in our favor, but I couldn't be sure. I wasn't completely sure. He's very careful, very careful. Couldn't be sure. So I think we've got the 5 votes. I'm pretty sure we've got the 5 votes. I know that many other people, like one of the chief lawyers for the Institute for Justice, Erica Smith, thinks her view is 90% we're going to win. I'm not quite that positive, but I think we're in a good position.
When will the decision come down?
The U.S. Supreme Court finishes its term at the end of June. COVID-19 hasn't changed the end of the term rule. The U.S. Supreme Court always decides the current cases by the end of the term, with small exceptions, none of which apply here. And so we expect a decision by the U.S. Supreme Court probably the last day or 2 of June.
And if Espinoza's case is successful, what does that imply? Does that imply that other Blaine amendments are likely to fall? What does that mean for?
Precisely. There are 38 states with Blaine amendments, 38 states. And it means that, at least to some degree, all of these Blaine amendments are subject to attack. And those attacks will come swiftly. And many of them will be struck down. What that means is that the following. Obviously, a program like the program in Montana that can then be created, whereby there can be tax credits enacted by the legislature, which can then are available to all through a scholarship program, which can then be used at a private secular school or a private religious school, which of course still has to meet state requirements, and that as long as the choice there is purely then private as to where that money goes, states can enact programs like that. But it's more than that. The programs can be fashioned in all sorts of ways, not only to aid bricks and mortar schools, they can be used to aid homeschooling costs or homeschool programs that are mixed a couple days a week classroom and a couple days a week at home. Now, I'm a vice chair of this college, Thomas More College. Obviously, I'm a religious person. And many people like me are not enamored these days of the public schools and think that they are a resurgence of the common schools of the 19th century, where the common schools at that time taught a general Protestantism. The public schools of this day teach a generalized secularism, and perhaps even a rabid generalized secularism. And people like me, millions of others, are increasingly unhappy with the idea of our children attending such schools and would very much like to step away from such schools, and especially the monopoly on, it's not just that public schools today are rabidly secular, they are in my view, often intolerant of others and demand conformity. Just like your great-grandfather was caned, I mean, students who don't accept the pervasive, rabid secularism in public schools, I recently heard reports that those students are subject to discipline, their parents are reported on. I could tell you worse. And so a lot of people want to have available to them another alternative, which is something along the lines of bricks and mortar scholarship programs or funding of homeschooling. Of course, the political pushback in many states will be enormous against this, especially by the teachers' unions. And this is the fight to come. Assuming we prevail in Espinoza, this is the political fight to come, which will be long and hard fought. At least it'll be a political fight and not vetoed by the ancient Blaine amendments.
So this is a fight we need to be getting ready to fight. We need to be getting ready for this possibility
I agree.
right now.
We need to get ready now because it's coming. And I would fully expect to see statutes enacted banning homeschooling. The teachers' unions will see this as a potential way out for folks, and secular influences will see this as a way out, and they want to prevent that escape hatch from their monopoly over truth in schools, their truth. And this is an enormous political fight to come between those who demand their truth dominate the public schools and those who have a different truth which they want to teach their children. So you're right, get ready politically. I don't think this has really hit the public radar yet. I don't think the religious people are fully aware of this issue yet. There were editorials about it in the Wall Street Journal and other places at the time this took place, which I thought was good. But what I did expect to see on the plaza in front of the U.S. Supreme Court that day, January 22nd, was huge teachers' unions groups and other groups, sort of slugging it out like they do every year on Pro-Life Day, which was the anniversary of the Roe versus Wade decision. They weren't there. And I was really surprised by that it didn't generate the intense political activity, especially from the teachers' unions, that I would have that I expected to see. But that time is coming, because some states will start moving toward, assuming we prevail in Espinoza, they will start moving toward this. And the teachers' unions will start to mobilize against it. And people will start to see this is a way out from the public schools. And so the forces in society will organize on both sides of this issue, I think strongly within the next 6 months.
Thank you for giving us the heads up. I think this is a very useful warning, and a call to action. So thank you for giving us the background.
I'm glad to do it, thank you.
Over and out.